Now, I asked you all to read the first case in here, that Edina case, about how buyer's agency technically took to a new level. And the Edina case created this urgency for us to make sure everybody knew who they were representing or who was being represented by who. So the clients or the buyer or the seller knew if they had representation or they didn't. Okay. Before then, if some of you folks who bought houses earlier than 1995, you know that everybody, when you're a real estate agent or a broker, you work for the seller. And that's what you said. And you told everybody, please be careful. I represent the seller. Well, what happened was, after this Edina case, which cost Edina Realty $19.1 million back in 1995 to settle it, the word got out. States and state laws and companies and everybody else made very, very sure that everybody knows who they're working for or who's working for them. All right. So when they sign that contract that says, I want you to represent me, either Mr. Buyer or Mr. Seller, they know that I have their best interest at heart. If they didn't hire me, if I worked for the seller and I was working with a buyer, whose best interest would I have? Obviously my seller's, right? So it's really, really important that we make sure that everybody understands, and also make sure that everybody understands what we owe them, our 6 fiduciary characteristics, right? So we have those. All right, so the first question, 1995. The Edina case prompted the North Carolina Real Estate Commission to revise its agency rule to require licensees to provide specific agency disclosures in writing. This is what we were talking about the other day, working with real estate agents, right? Tuesday night, we went through the seller's page and then the buyer's page. And then we went through that pamphlet, okay? So this was all came about. Now it's been revised a couple of times since then. Matter of fact, once just a year or so ago, but it's really important that we do that. And it's become first substantial contact. We need to review that document so that before they start telling us everything, they need to know who they're working with. And if they give me information, I might be obligated to tell a seller, tell somebody else. And that they need to know that right away. Now, if you tell them and they give you that information, well, you told them, but you need to prove that you told them because they don't remember. That's why you need to get that form signed. They forget that you told them that. You guys all know how many papers get pushed across at you when you buy a house, right? You should know that prior to even getting that far. All right, so again, everybody's got to give that disclosure in writing. Number 2, the term principal is synonymous with the term client. We're going to use client from this point forward, but principal and client are the same thing, and it means the person doing the hiring. The person who you are representing. You are the agent, okay? Person who hires is the client, all right? Or the principal, same thing. Number 3, a real estate broker acting as the agent of a seller. A is obligated to render faithful service to the seller, right? We have to be loyal. Obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill and care, right? In order to do faithful service, we have to be loyal, right? And they hired us. They hired us. So the answer is A. Number 4, fiduciary refers to B, the relationship of trust between the agent and the principal. They have to feel comfortable answering questions from us, right? The only way we can get inside their head is by what? Asking questions. And sometimes they're going to say things that you're going to need clarification on. And you're going to have to hold them down to specifics. So they have to be able to trust you in order to give you that information. Otherwise, down the road, it's going to be, it's harder to undo things than it is to do them right the first time. So we need to be able to do that. And you're going to get information from them that they wouldn't tell their family. So they need to be a fiduciary, and you need to be a relationship of trust. Number 5, when in the employ of a real estate broker, a provisional broker has the authority to assume responsibilities assigned by the broker. Your broker in charge, when you're a provisional broker, your broker in charge is going to give you jobs to do, and you're going to carry them out, whether it's fill out a contract, whether it's measure a house, whether it's go with them to take a listing, right? Whether it's to key it into the multiple listing system, they're going to tell you what to do, and that's how you'll learn, and that's how you'll be involved in all of these processes. Okay, so the answer is B, assume responsibilities assigned by the broker. Number 6, a legal relationship between the broker and the seller is usually what? It is a special agent. He gets hired to do one thing, right? Buy me a house, sell my house. What happens when that happens? Do we have any more relationship with them? No, it's gone. We get hired to do one thing. So our broker in charge our firm gets hired to do one thing. What about me as the broker who works for ABC Realty? And I was the guy who sold that house. When I come back, do I have to get rehired again? No, I'm a general agent. Same thing with a property manager. Every time we do something for a landlord who hires us, we don't have to be rehired. Okay, so we have what's called a continuity of service. We keep going. And then the third one you'll need to know is universal agent, and that is a guardian who's in guardianship, somebody who's an attorney in fact, somebody who can represent somebody else or work with somebody else in the whole, as if you were that person. You don't really want to do that as a broker. You can see there's a huge conflict of interest there, but just understand the 3 different types. Universal agent, you act as somebody else. A special agent, you get hired to do one thing and one thing only, whatever it says on that contract. Now, that contract could say 5 houses, but when all 5 houses are done under that contract, you're done. And then as a general agent, you don't have to get rehired. You keep coming back and you keep giving you more work. And it's okay. There's a continuity of service. We don't get rehired every time we're done. Okay, those are the 3. Designated agency is a form of dual agency. Designated, right? The broker in charge has both the buyer and the seller. Buyer and the seller, broker in charge has. The agent underneath there has the buyer and seller, buyer client, seller client, all right? But one of them doesn't want me to represent both. So I would take one side and we would get somebody else, an agent from our group, to do the other side. That would be designated agent. Or if Callie and I work for the same company and she brought the buyer and I had the seller, we would be designated agents because our broker would be a dual agent, but we would each be separate. We would be able to do our entire job, our whole old car responsibilities. All right, we can do that. All right, she can take care of her client, I can take care of my client. All right, so that is what designated agency is. Number 8, a real estate firm who engages brokers as independent contractors must D, still supervise the brokers and remain civilly liable for the brokerage activities of the brokers. Now, this is where real estate differs, okay? When you are an independent contractor, technically you are called a qualified contractor under the rules and regulations. Because if you're an independent contractor, you own your business, and by the letter of the law, you don't have a boss, and nobody's going to be responsible. You're going to be totally responsible. Well, in real estate, if you're the broker, you're an independent contractor, but if you do something that's not correct, your broker is responsible, as are you. So they're responsible to make sure that you're doing the right thing. So it's a little bit different. You're a qualified independent contractor in this particular case. All right. So your broker is still, it's a little bit different than being a pure independent contractor. Number 9, single agency occurs when a real estate agent A represents only one party in the transaction. We're only going to represent the buyer or we're only going to represent the seller. There will be no dual agency. There will be no designated agency. All right. There will be no seller sub-agency when we're both representing the buyer, okay, or the seller rather. I'm sorry. We're going to have either the buyer or the seller. That's it. All right. And if we can get both, we're going to have to send one away or have them work independently as a customer. You can't help them. Number 10, an agent who breaches the fiduciary duties may be subject to all of the following except, okay? So let me do the bad ones, all right? You can be civilly sued, yes. You can be disciplined by the real estate commission, yes, okay? Your license can never be suspended by the Association of Realtors, okay? They don't have that kind of power, but they can fine you and they can take away your realtor privileges, all right? And so that's the answer to this, the accept answer. And then you can be criminally prosecuted if it is bad enough of a breach of duty. Number 11, the principal owes the agent. This is the person doing the hiring, owes the agent duty of acting in good faith, absolutely, and payment of compensation. All right, both 1 and 2. All right, just an off the record thing. You have got, it's one of your first jobs, not so much on the seller side, because the seller's going to let you sell the house, let people come in and all that other stuff. But if you're going to work with buyers, which you always think is easier, but it's not, make sure they are a real buyer, right? Make sure that they're not out for just something to do on a Friday afternoon. Got to get them pre-qualified. Now, let me, before I even jump into that, make sure you get into a pattern of doing everything the same way for every single person who walks in the door. Do not pick and choose what you do. So if everybody who walks in the door gets the working with real estate agents disclosure and you tell them that, and then immediately after you ask them if they're pre-qualified and they say no, and you send them to the banker de jour, whatever that one is, to get pre-qualified, okay, make sure you do it for everybody. Because if you start picking and choosing or you start doing it randomly, you're going to get in trouble. It's a violation of fair housing. You're going to get in huge trouble. All right. Somebody will bring it to you. So make sure you get into a pattern. Talk to your broker in charge, but it's not random. It has to be done every way, whatever way you decide you're going to do it. All right. But make sure buyers are buyers. Gas is $4 a gallon, if I remember correctly. You start driving them around, it gets expensive for them to kill time before they have dinner reservations, right? So you can do that by pre-qualifying. And if they say they're paying cash, ask them to see the bank statement. And tell them they can cross out the account numbers and social security numbers. You're not interested in that. You want to see their names on it, and you want to see the money in the bank. Okay? Otherwise, you're wasting your time. Number 12. North Carolina, the doctrine of caveat emptor, B, is still intact for property owners in real estate transactions. We're going to talk tonight about our residential property disclosure form. And on it, you're going to see a third column that's going to say no representation, which means that your seller doesn't have to say anything. I'm not telling you this, I'm not telling you this, I'm not telling you this, I'm not telling you this. And this document is 5 pages long. However, you as the broker are not covered under caveat emptor, only the property owners. You must disclose any problems that you know of on that property, okay? You are not covered as a broker. All right, number 13. Under the common law of agency, a real estate broker owes all of the following duties to the principal, except, all right, what's our old car, right? Care, obedience, disclosure. The only one that's not there is novation. Novation. All right. All right. Seems like a big electronic night tonight. We're just having some problems too. It was fuzzy. We'll get through it. All right. Novation is something else altogether. When we get into contracts, we'll talk about novations. Number 14. An agency relationship may be legally terminated by all of the following means except. Okay, so the answer is B, but let's talk about the ones that how you can terminate. So A says the owner decides not to sell the house. What are you gonna do? You can't make him sell his house, right? You're only in a listing stage. So obviously we can terminate that listing. If the owner dies during our listing is terminated, okay? D, the broker secures a ready, willing, and able buyer for the seller's property. That's it, we've earned our money, done our job, right? So we've done all of that. So if the broker discovers that list price will not yield an adequate commission, obviously that's ridiculous. You cannot ever stop a sale for that. Oh, remember this as you're going through your careers. If you get into a dispute with another realtor at the closing table about commission split, please, please, please never stop the closing because you and another real estate broker are complaining or bickering about commission. Have the attorney put it in escrow and fight about it afterwards, because you will end up losing your license faster than you can possibly bat an eye. All right, the real estate commission will not tolerate that. Zero. All right, they're there to protect the public, are they not? I told you that the other night. Their job is to protect the public, not two real estate agents holding them up because they're fighting for commission. Don't do it. All right, don't do it. Just a FYI. Number 15. The broker represents the seller at an open house. When should she disclose her agency relationship to a potential buyer at the open house? Somebody comes in and you're holding an open house, and somebody comes in, sits at the kitchen table and says, hey, I'm really thinking about buying this house, and I need to buy a house like tomorrow. Well, you have to stop them, right? And you got to tell them. You got to give them the working with real estate agents disclosure. And they can decide whether they want to work with you or not, or how much information they want to give you. But you have to tell them, I'm working for the seller, but I'd be happy to help you if you want to sign a buyer's agency. In that particular case, we would be in dual agent. But once she starts giving you facts, right? Price, terms, or motivation of her purchase wants, then we have to stop them and give them that working with real estate agents disclosure. Number 16. A broker is representing the property seller. She's showing the property to a prospective buyer customer. The buyer likes the house but does not want to pay as much as the seller wants. He asked the broker if the seller would take less than the listing price. The broker knows that the seller is very anxious to sell and would probably agree to $7,000 less than his asking price. The broker suggests that the buyer make an offer $5,000 less than the listing price. In this situation, the broker has B, violated her fiduciary duties to the seller. Why? Because she's supposed to be loyal to her client, not to somebody, a customer. So she can't give away price, she can't give away terms, can't give away motivation. Well, here she's just gave away $5,000 of his money. Now, she could have said, make an offer and we'll see if he'll accept it. But she specifically told them that he would take less money, right? So you violated your fiduciary duties. 17, an agent representing the seller. The agent shows the house to his cousin and she is very interested in buying it. The agent presents his cousin's full price offer to the seller, who eagerly accepts it. Both the seller and the buyer are very happy with the transaction. Which statement is true? And the answer is C. The agent's violated his fiduciary duties to the seller by failing to disclose his relationship with the buyer and could be subject to a disciplinary action. Disclosure: this is a cousin. This person who is buying it is a family member. You need to disclose that information to your client, right? Those things are important. Who's to say that you didn't give a better deal because it's your cousin, right? Maybe the seller doesn't want to deal with somebody who's your relative. You have to let people know that. All right. It's always easier if you're honest. It's always easier if you're honest. Just tell them everything, right? Tell them everything. Not going to hurt you. Number 18, seller tells the listing agent about a latent defect in the property. The listing agent tells the buyer's agent about the listing agent tells the buyer's agent about the defect, but the buyer's agent does not inform the buyer. Who would most likely be held responsible for the omission in North Carolina? It's going to be the buyer's agent, right? So it's D. The buyer's agent didn't tell their client, and they knew, all right? So in this particular case, it would be omission. It would be negligent omission, right? Because they shouldn't withhold with information from their client, okay? Should not withhold. Number 19, if a broker's misrepresentation causes loss or financial injury to a buyer customer, which of the following could be found liable? Okay. Both the principal and the broker could be. Both the principal and the broker could be found liable. In this particular case, if there is something wrong, right? Both of them. You go to court, you can get sued for everything, and they'll sue everybody. So everybody will share in the cost. Mostly the broker, okay, because the broker should have known or found out. But if the principal lied, what if the principal lied to the broker? The broker didn't check it out. Both of them are going to be in trouble. They'll both be liable. Number 20, which of the following statements about dual agency is or are correct? Number 1, dual agency can occur within one firm if a broker shows his buyer client his or her own listing. That makes sense, right? You have your own listing, you show it to a buyer, then that is dual agency. And number 2, dual agency can occur within one firm if a broker has become a buyer's agent and is showing a property listed by the broker in charge, right? The broker in charge is a dual agent. He's got both his listing and he's got your listing, your buyer. So both are dual agencies. In our particular, number 2 would be the designated dual agency because we have 2 parties, but a designated dual agency is certainly still dual agency. Number 21, under North Carolina license law and commission rules, which of the following is true concerning designated agent? Number 1, the broker in charge cannot be a designated agent. Certainly the broker in charge can be a designated agent. He just can't be a designated agent with who? His own provisional broker, right? They can't be designated agents together. They could be dual agents, all right? But they can't be designated. And number 2, an agent cannot be appointed as a designated agent if she has prior confidential knowledge about the other party in the transaction. That's true. So if let's say Callie and I have 2 parts, right? I have buyer and seller. And Callie went for that listing appointment and she didn't get it. I got it. I got lucky enough to get it. Okay. She was having a bad day. I was having a fantastic day and I got lucky. So what happens now is that if I have to split those because they don't want me to be a dual agent, I can't give it to Callie because Callie has what? She has confidential information from the seller, right? Because she went for the listing appointment. So she knows a lot of stuff. So if she has confidential information, she can't be appointed. I'd have to go find somebody who doesn't have any confidential information about either the buyer or the seller at this point. And then we can appoint them as the other designated agent. Okay. Number 22, it is discovered after a sale that the land parcel is 10% smaller than the owner represented it to be. The broker who passed the erroneous information on to the buyer is D, liable if the broker knew or should have known of the discrepancy. If you put it in the MLS, you're responsible. And we're going to see in 3 or 4 slides here down the road that the MLS will give you 5% plus or minus. But you have to you don't have to even do it. You don't have to put it in the MLS. You don't have to disclose. But if you're going to disclose, it has to be accurate, plus or minus 5%. Okay? So when you're measuring houses, All right. 23. A broker is representing the property seller. An agent at the same firm is representing the buyer. The two agents conferred during a sales meeting and discovered the compatible needs of the clients. All of the following are true except, okay, let's go through the true ones. Number one, A, the listing agent is being diligent trying to find a buyer for the seller. Okay, that's true. B, the second agent is performing his fiduciary duties to the buyer. Again, trying to find a house, right? And D, if the parties have consented to dual agency, the broker in charge can allow the two agents to continue their representation in brokering this transaction. All true, okay? The one that isn't, it says, is the broker in charge must designate two other brokers who did not attend the meeting to represent the clients. No, I'm going to meet with other agents all the time, try to work out a deal, try to get something together. What do we need to do? How far apart are we? We're going to try to talk about it. I need to do what's best for my client. So again, we're trying, that's what they're doing here, okay? They're trying to meet, discover needs, right? Okay, without giving away price, terms, and confidentiality, right? Price, terms, and motivation. Number 24. Which of the following situations would be considered a material fact that would require disclosure by a North Carolina listing agent, okay? And the answer is D, the house was totally replumbed after the polybutylene pipe broke in the master bathroom. Remember the three things I said, even if you have them fixed, you had to disclose polybutylene pipes. If it was a methane lab, right? If they're cooking meth. And the third one was synthetic stucco. Those three. Even if there's all been fixed, you still have to disclose it, okay? But the other three are stigmatized properties, and you don't have to do those. All right, you don't have to disclose them. They're not mandatory. Number 25, in auction sales. Letter C, a written listing agreement between the seller and the broker is required from the outset of the relationship. All right, what happens in an auction sale? Remember we talked about price, terms, and motivation? Well, the auctioneer has a listing agreement with probably the bank who's selling the house or the person who's auctioning the property, okay? So they're the seller. If we're in an auction house with 100 people bidding on properties, how do we give them the disclosures? How do we do the working with real estate agents disclosure with them? You can't. They're telling you price all day, right? They're raising their hand. I'll pay 300. I'll pay 325. I'll pay 350, right? They're going. So everybody knows that. However, immediately after they win the bid, they must be given the worker with real estate agents disclosure. Okay? So we can't give it to everybody who's going to bid, but if they win the bid, they immediately have to be given that disclosure, the agency disclosure. Okay? So just a FYI on that. I've seen that question pop up. Okay. Can't possibly give everybody that disclosure, but once they win the bid, you can. Number 26, a North Carolina listing agent has the seller's permission to practice dual agency. A different agent with a listing firm holds an open house over the weekend. Prospective buyer attends the open house, but never shows an interest in the open house property. Buyer begins to discuss his specific needs for the property with the agent hosting the open house. The agent must stop the buyer's information sharing until they've reviewed a working with real estate agents form and decided their agency relationship, right? So maybe we have an open house and they don't want this open house. And they sit down and start talking to me about, well, this is the kind of house we want. I have to stop them, right? That's the pretense of working with real estate agents disclosure. Once they start giving me that information, I got to say, all right, look, you and I don't work together. If you give me confidential information, I'm going to have to share it. So don't unless you hire me. Number 27. A North Carolina broker wishes to consummate a transaction where he represents neither the buyer nor the seller. This relationship B is prohibited in North Carolina. We cannot be a facilitator. We cannot be a transaction broker. We have to be one of three things: buyer's agent with a contract, listing agent with a contract, seller sub-agency that's hired underwriting. Okay, that's it. That's all we got. If you're not one of those three, you cannot consummate that transaction. Number 28. A broker in charge wishes to pay a provisional broker under her supervision for closing a transaction. This is permissible if A, the provisional broker is properly licensed. You can't pay anybody who doesn't have a license, doesn't have an active real estate license. You can't pay anybody unless the money was earned while they were active. Okay, so you can't pay anybody. So if the provisional broker is properly licensed, they can get paid. Last one, termination of agency may be accomplished by A, completion or performance of the purpose of the agency. True, right? We sold the house, we bought the house, good. Destruction or condemnation of the property. Can you sell a house that burnt down to the ground? Probably not, right? So termination. Mutual agreements of the parties. Maybe they decided they didn't want to buy anymore. Maybe they decided they didn't want to sell anymore. Maybe they realized that their credit wasn't enough to borrow money. Whatever that is. So all of these were reasons for termination. All of those are reasons for termination. Okay? Don't lose sight of chapter 2. Don't lose sight of chapter 7. Chapter 2 more for the national side of the exam. Chapter 7 for the state side of the exam. So at the end of last class, we went through most of the listing agreement. We'll let you read the rest of it. There's kind of makes sense as to what we're doing. In addition to that, there are some other things that we're going to want to get because the buyer is going to ask for them. As sure as anything, the buyer's going to ask for these things. I want to see, if I'm the buyer's agent, I want to see the seller's deed. Make sure they own it. I want to go check it. I'll go to Register of Deeds and make sure that they own it. Make sure there's no list pendants. You all remember list pendants? Did we talk about that? Upcoming lawsuits, right? If I'm going to be a buyer, they're going to get foreclosed on in 30 days. I might lose a lot of money getting all my stuff ducks in a row, right? So I want to make sure. Copy of the survey, right? I want to make sure there's no encroachments on this property. I want to make sure the property lines are where they're supposed to be. All right. So if I'm the buyer, I'm looking for a copy of this. So as the listing agent, you might as well get it. Okay. A copy of the protective covenants, the CC&Rs from the subdivision. If you live with an HOA or a COA or a POA, they're all the same. If you live with those, you got a copy of your deeds and restrictions, your CC&Rs, covenants, conditions, and restrictions. All right. Well, the buyer is going to have to abide by those. All right. Because they're what? Appurtenant, they run with the land. So that buyer is going to have to abide by those. He wants a copy of them, and you should be giving it to them. So the best thing to do is, as the buyer's agent, is ask the listing agent. Should have it. Now, if I'm the listing agent, I want to know how much they owe. How much do you have on a mortgage? How many mortgages do you have? What's the value? Because what happens if they got more mortgages than they can sell the house for? Then we get into short sales. We get into, if you'll take a short sale, they'll get into foreclosures. They'll get into, the price being too high. Nobody will come and buy it. And they'll get into slicing your commission. All right. Because they can't make enough money. All of those things are important. So we need to know that. We need to know that. Right? Things we need to ask. Okay, so we talked about, before we left on Tuesday night, we talked about 3 different types of listings, right? Open listing means we have multiple agents listing a property, and the only ones that are going to get paid are the ones who bring the buyer, but the seller holds the right to find the buyer himself and not pay. All right, the MLS has pretty much eradicated that one. It's not illegal, and it does happen on occasion. I've never seen one in I don't know, 14 or 15 years doing business now. Okay. So that's open listing. Exclusive agency. If we have that, that means that we have one agent that's hired to sell that property. But the seller can sell it by himself and not pay the agent. So that is going to be a problem. All right. Guy walks up to the front door, knocks on the door, says to the seller, Mr. Seller, I want to buy the property. Even though he might have seen my advertisement and everything else, he don't have to pay me. He can say he found it. All right. Now, the one we're going to use mostly is called an exclusive right to sell. An exclusive right to sell. And that is one agent, however, one broker, however, as many, anybody can bring it. If that house gets sold, we get paid. Seller can find it himself. We can have somebody from another company bring it, whatever. Okay, we're still going to get paid. So that's the one we're going to use, an exclusive right to sell. Now, there is a fourth one, and it's called a net listing. Now, this is not against the law in North Carolina, but it is strongly discouraged that we do not use it. And what this says is that, I'll read it to you and then we'll talk about it. Broker agrees to sell any property for a set price, and the broker collects any monies charged over that set price as their commission. So, grandma's selling her house. She says, if you give me $200,000, you can keep the rest for commission. And I know that it's $400,000 worth of house there. So do I have a conflict of interest? Who am I working for? I'm not working for grandma anymore. I'm working for who? Moi, right? I'm working to get most money for me. So therefore, the conflict of interest is I'm going to be taking everybody to this house, trying to sell it for the maximum dollars because grandma's going to get her money. Now, is that fair to grandma? Not fair to grandma, right? She should get the, $400,000 less your commission. It's her money. She's earned it, the equity there, okay? And in the listing contract, there is a space for that. How much she's going to pay for commission, what we think the value of the house is going to be, all right? So a net listing says that, all right, look, Sam, give me $200,000 and you keep the rest. That's a net, right? I'm going to get paid off the net. And that's not good. All right. So use of net listing arrangements is strongly discouraged due to the great potential for abuse and fraud. It's pretty self-explanatory, right? When you think about it, it's dangerous business. So we don't want that to fester. All right. All right. So net listing would be that one. It's not illegal in North Carolina. It is illegal in some states, but not North Carolina. Just not strongly discouraged. Don't do it. The North Carolina Protection Agreement, we basically what this is that if I go to let's say I go to a for sale by owner, and I am the buyer's agent, and I walk in there and I say, I have buyers in my car that are my clients, and I would like to bring them in here because they have interest in your house. Will you pay me a commission? Whatever we figure, 5%, 6%, 7%. Will you pay me that 7% commission? And I'm going to bring him a piece of paper. I'm going to bring a document for him to sign or her to sign that says, yes, if these people buy this property, I will pay you X amount of dollars. That's a protection agreement. Now, if he tells me to crumble up that piece of paper and put it, where, I got no bearing with him, so I got to go back to my clients in the car, and I'm going to tell them that, okay, he's not going to pay me anything. We're going to have to go back to your buyer's agency agreement and see what we put in there, and you're going to have to pay the commission. And if I went and said on the buyer's agency agreement, and you can all read the buyer's agency agreement, it's out there in your Dropbox. If in the buyer's agency agreement, I said that don't worry about it, I won't charge you anything, I'll get paid out of the seller's commission. And he just told me, no, he wasn't going to pay me. We now have what's called gratuitous agency. which means that I still have to do the work for my client. And now if they want to buy this house, not only do I have to do the work for my client, am I going to be keeping the for sale by owner in line too? Because we got to get this thing closed, right? Right. And he's not going to pay me commission. And I told the buyers they're not paying me. They don't have to pay me commission. So how much am I making for this deal that I'm going to be working twice as hard for? That's right, nothing. Now, that's not going to make my mortgage company very happy, and it's really not going to make my broker in charge happy. Okay? So you got to protect your commission. That's why you got to put in the buyer's agency agreement. If I don't get paid by the seller, you're going to have to pay me. Right? But that's what this protection agreement is. I go into the for sale by owner and I hand them the form and say, hey, you got to pay me. If they come in and buy this, you got to pay me. And he can sign it or not. All right. So it's used by a buyer agent to secure the commission if property is procured directly by the agent's buyer client. Okay. Often utilized in conjunction with for sale by owner transactions. All right. So that's how you would use that. That would be a North Carolina protection agreement. Now, we all are familiar with the MLS, right? And this is where we list, and that's the multiple listing service, okay? This is owned by your realtor organization in most cases, some cases not, but in most cases it is. And this is where we put all the details about the house, about the property. It's also where we put our broker cooperation fee. In the multiple listing, it says we're going to share, or we're going to give 2, 3, 4, 5, 10% to the buyer. Okay, whatever we decide that's going to go in there. If we're getting 15%, we may put 8% in there for split it. If we're getting 3%, we may put like a flat dollar fee to the buyer, to the buyer's agent. But it'll all be listed in the multiple listing system. Okay, so that's where the broker's compensation, the broker cooperation is going to be. Let's talk about square footage. Inside your Dropbox is a measurement booklet. If you haven't got your Dropbox or you haven't figured it out, I just put it in the chat box. This was written in 2013, 10 years ago. It's probably the best book you're ever going to get on measuring a house. Honest to goodness, it is the best book you'll get on measuring a house. So let's just quickly take a look at it. And it says residential square footage guidelines. This square footage guidelines is written by the Real Estate Commission. It was written in 2013, and the only reason I know that is because it says so. Copyright 1st, 1999. So if you are ever interested in the details of how to measure a house, please read through this. We're going to talk about 2 or 3 or 4 different slides. We won't have time to go through all of this booklet, but I just gave it to you, and this is some good definition of how to figure out heated square footage. How to figure out what a finished wall is. It has to be painted drywall, sheetrock, panel, right? Not just studded walls, all right? Ceilings have to be a minimum of 7 feet high, okay? Can't be less than 5 feet tall. They have to be directed. In order for it to be heated square feet, it has to be directly from another heated square foot area. So I can't walk outside to go above my garage where the mother-in-law suite is, counted as heated square foot. I can count that as additional square feet, but I can't count it as heated square foot of the main house. All right. So all of this is there. This is a great thing to read. Just graze through it. You'll be surprised how much this helps you. All right. So it actually, we'll go through some of this stuff. Starts with some pictures, and you can kind of look at, all right, if we were looking at a little ranch, they'll give you the diagram so that you can go and see how they're measured with a lot of detail in there. I'm not saying that you're going to get what we're going to cover in the slides is going to be important. This is going to be a handbook that you're going to want for day to day. This is going to be a handbook that you're going to want from day to day. And you could probably order this booklet from the Real Estate Commission themselves. I don't think it costs much more than a couple bucks, if it costs anything, but you might want to order it. It's a good thing to have. Because someday you're going to get into a house that looks something like, what happens if that house looks like that custom house? And then you got to do all of this measuring. Not unusual. Let's talk about what we need. We are going to measure this property. Now, keep in mind that measuring and square footage is not mandatory. We don't have to do it. It's not required. It's not a material fact. If we want to, we have to be accurate. If our seller wants to, he has to be accurate. But we don't want, we want to. Now, please also keep in mind, if your buyer wants to and you're the buyer's agent, guess what you're doing? You're going to measure a house, right? So you need to know. Now, when we measure houses, we don't measure them from the inside on the bottom floor. We measure them from the outside. We measure everything on the outside, all right? So measuring heated living area externally, outside. If we get to the second floor, obviously we can't stand on a ladder outside and measure the second floor. So we're gonna have to go inside. And we're gonna measure from one end to the other and then back and front. And then we're gonna add 6 inches for every wall, every exterior wall. So from upstairs, if it measures 30 feet long, we're going to add 6 inches for the left wall, 6 inches for the right wall, and it's going to be 31 feet. Same thing with front and back. If it's 20 feet front and back, we're going to add 6 inches for the front, 6 inches for the back, so it'll be 21 feet. That's how you measure inside. So again, not a material fact, but you are going to be responsible if you put something out there that is wrong. So I showed you the residential square footage guidelines. Keep in mind, air conditioning is not required. Air conditioning is not required. Heated is, okay? And it has to be able to heat a room permanently 4 seasons to 65 degrees when it's 20 out.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.